We cannot afford to go back to the 70s, 80s.
I agree. By the way, Central Park, you're talking about incidents of violence. Central Park is the safest police precinct in the city of New York.
So moved.
2019 Borough Board Meeting Agenda.
So moved.
Second, all in favor?
Aye.
Thank you. The ayes have it. And can I have a motion for the adoption of the November 21st, 2019 Borough Board Meeting Minutes? Thank you. All in favor?
Aye.
The ayes have it. Okay, today we are going to have a presentation on the Housing Stability and Tenant Protection Act of 2019 by Legal Aid Society staff attorney and my dear friend Ellen Davidson. Ellen, you want to come up here?
Yeah, sure. Clicker? All right.
Is this a good angle or should I put it over here in the middle?
The center, yeah, would be much better. Just a good.
How's that? Okay.
It's fine. It's great.
Borough board meeting. Center might be.
What am I doing wrong?
Should be left and right on that, right?
I'm left.
Let's see if I can. There we go.
I know I can get forward. I can't go back.
It should be the other side.
Probably needs batteries.
No, it's not.
It needs batteries probably. Or we could just use it.
I'll start you at the beginning.
All right.
We could use the laptop just as it is.
Sure.
I mean, the arrow on the laptop. You want to do it that way?
I think. All right, I'll try not to double click. I've done a lot of these conversations. I feel like I've toured the laptop and PowerPoint capabilities across the city. Which has been fun. Anyway, so I'm Ellen Davidson. I'm a staff attorney at the Legal Aid Society. I was asked to come and talk about the tenant stability, the Housing Stability and Tenant Protection Act of 2019. I was recently at a meeting at HCR, the state housing agency, and they're calling it HESPA. I don't love it, before I start, I guess a comment on the title. So I've been involved with a lot of the rent regulation fights over the years in 2011, 2015, and those laws were all called the Rent Regulations Act of 2011 or the Rent Law of 2015. And the reason that this law is actually, you do not see rent regulations in its title is it's much, much broader than just changes to our rent laws. In fact, and I'm not going to be talking about this, but in fact, the last section of the bill has the strongest protections for manufactured home communities in the country. New York City has one manufactured home community. It's in Staten Island near the Goethals Bridge. But for the people who live in manufactured homes, they got hugely new and strong protections because this is a very broad law that protects tenants in all corners of our state. Okay, so however, what New York City folks want to know First and foremost is how does it affect the rent laws? And so I'm gonna start with that. And I guess the first thing to say is that before June 14th, 2019, that's the effective date of the act, the date the act was passed and the date that the law was signed. Landlords could remove units from rent regulation through two types of decontrol. One had to do with, this is the one that was much, the smaller part of deregulation came from in-place tenants whose apartments had reached a certain rent threshold. Most recently, it was $27.74 and 76 cents. And they had incomes of $200,000 or more, their household incomes for 2 or more years. That was called high rent, high income decontrol. We actually know exactly how many units were lost through this because a landlord would have to apply to HCR to get an order to deregulate the unit. And in fact, no matter what you hear from the real estate industry about how many people of over 200,000 household income live in rent-regulated housing, in the over 20 plus years that this type of deregulation was in existence, somewhere around 11,000, 12,000 units were lost to deregulation. So a very small part of the deregulation, somewhere around 11,000, 12,000. It's in the Rent Guidelines Board, does great reports about changes in rent regulation, rent-regulated stock, and that's where and they get their numbers from DHCR, and that's where my numbers come from. The other type of deregulation was called vacancy deregulation, and that was, again, if an apartment hit a certain rent threshold and that apartment was empty, the landlord could deregulate. That was not a type of deregulation that required an application to HCR. It actually didn't require anything. And hundreds of thousands of units have been lost to deregulation since 1994 when it first came into the system. It's that form of deregulation that led to the massive scandals around construction abuse that certain parts of the city have seen, where landlords did everything possible to make lives really, really miserable to long-term tenants to push them out. The third, just a note about 421A, which I know is an issue in Manhattan. Up until 2015, 421A did not, in 421A buildings, you could do no deregulation as long as you had the 421A credit. For buildings under 421A that were built post 2015, you could deregulate them. And There was a change in the 421A law that basically said that high income, that there could be high rent decontrol. If you had a vacancy in a 421A unit, you could deregulate them. And I will tell you that HPD has told me that they read that to say that for any market rate 421A unit built after 2015, that it starts out as deregulated. I think that it's after the first vacancy, they disagree, and they're telling landlords that those units don't have to be regulated. For the affordable housing, it's different. They have to stay regulated. So after June 14th, there's no more deregulation within the regular rent stabilized stock. Anything that's rent regulated because it entered the system because it was built and occupied before 1974. The 421A units, those market rate units built after 2015, will still be deregulated because the law that was amended was not the 421A law, it was the rent laws. Now, just so this is on your calendar, 421A did not expire last year like it has in previous years where it expired. It was linked to rent regulation. They both expired at the same time. So in 2021, 2022, I forget which, I think it's 2021, the 421A law will sunset. And to the extent that people think that there are changes that should be made to that law, there's an opportunity. All of this is effective immediately. And for current tenants who are in the process where their landlords had applied to deregulate their units because they had high income, my understanding is HCR is taking the position that if there was no order issued, if they were in the process of getting the order, they will not deregulate those units. It used to be that when a landlord managed to get an empty unit, they could take a vacancy bonus, a 20% increase. And in addition, they got a larger increase if there hadn't been a vacancy bonus in 8 years. It was considered the vacancy bonus longevity increase. Those have been repealed. The Rent Guidelines Board, during our financial crisis, added additional increases for low rent apartments where people have been in those apartments for longer periods of time. They no longer have the power to do those increases, and they can't issue vacancy increases on their own, which before 1997, they had the power to do so. For in-place tenants, the most important changes are for preferential rent tenants. Preferential rent simply means that a tenant is paying less than the legal rent. That's the only definition in law. And it used to be that at each and every lease term, that preferential rent could be taken away, which put preferential rent tenants in a lot of jeopardy. Our experience as the Legal Aid Society is we would go into a building that had significant repair conditions, and we would talk to the tenants about bringing a group case to get the conditions addressed. And the preferential rent tenants did not want to participate in those proceedings. They were terrified of complaining to their landlord about repairs because they knew they were at risk of seeing $100, $200, sometimes a doubling of their rent upon making any sort of complaints. Additionally, what we understand from the agency is that landlords use this preferential rent, legal rent system to cover up a lot of fraud. And so a lot of tenants ended up, what they were paying was called a preferential rent, and there was some number that had bared no resemblance to reality, to what the law was, that was set as the legal rent. But the tenant didn't make an overcharge complaint because frankly it wasn't really an overcharge complaint. What they may have been paying was legal. As soon as they left, there was, the landlord could then do whatever they wanted with it, deregulate the units. And so we think that a lot of tenants who have preferential rents, what's been written down as the registered legal rent should be investigated because HCR did an audit of a number of preferential rents some time ago and found that 50% they couldn't justify. So the new law is that if a tenant had a lease that was to be renewed after June 14th, 2019, then they get to keep their preferential rent. So as long as they live in the apartment, as long as the tenancy exists, which I will tell you frankly, I interpret to mean that any successors, if they leave, will get the entitlement to that. That's how I read it. That is, I will tell you, an open question that hasn't quite been laid out, but I think the courts will rule that way because it makes sense to me based on the law. When they leave the apartment, the landlord can then increase the rent to the legal rent, which is why I think it's really important that since now that preferential rent tenants are secure, that they be encouraged to apply to HCR to make sure that their legal rent was entitled to it, especially because there is going to be an incentive to get rid of preferential rent tenants and jump the rent up. So the more that they can make sure that their legal rent is not outrageous, crazy, no one's looking at it, and that is at the right amount, the better, safer they are. The other thing is that rent control tenants, which are, at this point, there's about 22,000 units of rent control left in the city. There's a very complicated formula for rent control tenants, which, if you've ever worked with rent control tenants, they can teach a seminar on how it works. There's no tenant in the city who understands their rent better than rent control tenants. But there was a very complicated formula, but what that formula led to was that landlords who were entitled to a rent increase, rent control landlords who were entitled to a rent increase, those tenants could see up to 7.5% increase every year, plus they would get fuel pass-alongs. There's now a new formula, which is the lesser of 7.5% or an average of the last 1 year rent guideline board increases, which the math is that for this year, those tenants will face the lesser of 7.5% or 0.75%, which is the average. So significant relief to rent control tenants who tend to be older and poorer than tenants pretty much anywhere else. There's no more fuel pass along. So the rent control tenants who have been fighting for these changes for decades have finally gotten some relief, which is really wonderful. So major capital improvements are those improvements that a landlord does to an entire building. We're talking boilers, roofs, facades, elevators. It's not supposed to be the individual improvement you get in an apartment. There's an article in the Wall Street Journal saying that landlords are no longer renovating their apartments because of the change in the law today. And one of their experts explained that everyone wants a dishwasher. I want to just say dishwashers were never allowed as part of major capital improvements. The way the law used to work was incredibly complicated, and so all the changes to the way the law now will work are also incredibly complicated. They also require action from the state agency, which has not taken action yet. So some of what, I don't know the answer to how some of these policies are going to work in practice, because HCR is going to need to do regulations. And the first and most important is that up until now, HCR has been paying verifiable costs that the landlord made. Some of you may have read about the landlord who did terracotta tiles on their building, and there were tenants who were facing an $800 increase because of these tiles. So now HCR has to create a schedule of reasonable costs for the repairs the improvements that will be made. It used to be that a landlord, the calculation of what an MCI, how an MCI would go into effect was based on a payback period of 8 or 9 years, depending on the size of an apartment. So that has been moved to 12 and 12 and a half years. So 8 or 9 to 12, 12 and a half. So buildings with 35 units or less, or fewer, I guess, it's 144 months. And buildings with more than 35 units, it's 150 months. This is part of how they calculate what the actual increase will be. It used to be that when tenants, even the tenants with the $800 increase, they couldn't, the increase could be no more than, in the old law, 6% a year. That's been moved to 2%. It used to be that the landlord was entitled to the increase from the day he filed the application, which meant that once a tenant got an order for the increase, after the increase was fully phased in, they then had to pay the landlord for the months while he was waiting for his MCI. It's called retroactive charges, it was temporary. but there are no longer, once the increase goes into effect once the order is in effect. MCIs expire after 30 years, according to the law. I have no understanding on how that's gonna work. Doesn't make sense to me, frankly. But that's the law, and HCR has been tasked with figuring out how to take MCIs off after 30 years. I mean, I guess I'll be around in 30 years, but be very surprised if this ever goes into effect. But I will tell you that there's a lot of complaints about this. MCIs must be essential for the preservation, energy efficient functionality, infrastructure of the entire building, but not for operational costs or unnecessary cosmetic improvements. I think the terracotta tiles probably fall into that. I think making lobbies beautiful probably fall into that, and those will no longer be allowed. I will note, especially since we passed the Green Buildings Act law last year, or whatever we're calling it, the law now explicitly says if a landlord makes energy upgrades, that should be an MCI, and it should be billed to the tenant. Before then, there were arguments about whether or not those should be, but the legislature decided they wanted to make sure to encourage landlords to do energy efficiencies by having them be compensated for it. Work inside individual apartments is no longer eligible. There were a couple of notorious landlords, mainly in the Bronx, who would take out everyone's kitchens and bathrooms while they were living there and then replace them and then give them an MCI, which was terrible for the families who lived there and had to live through the construction and pay full rent. And then at the end of it, what they got was an increase. That's no longer allowed. This is important for Manhattan. If a building has, if there are 35%, less than 35% rent regulated units left in a building, the landlord can't get an MCI. And that if there was no order before June 14th, if the landlord had applied for an MCI, had not yet been granted the order, that provision is being applied to those orders. So if you know of any buildings where the landlords applied, but there was no order yet, you should check to see about the percentage of units left that were rent regulated in the building, because those tenants could be not having an MCI, which would be great. Building must be clear of all B and C violations. I don't know how this is going to work. I don't know if they're going to give the landlord some time to fix it, or give an excuse on why there are B or C violations. We had a meeting with HCR, and they said they haven't worked out how it's going to happen yet. Increases go into effect the first of the month after giving 60 days of notice from the mailing. There's a new audit and inspection requirement that HCR is going to have to come out and inspect 25% of all MCIs done to make sure the work was actually done. Again, I don't know how that's going to work. So I know this is hard to see, but this is just math to show what this means, what these changes mean. So if you assume that the landlord spent $1 million in a 100 unit building, the MCI increase is $10,000 per apartment, divided by 96. This is under the old law. The tenant would be facing $104 increase. If that tenant had $1,000 rent, for the first year they'd see $160, because remember there was a 6% cap. By the second year, the increase would be fully phased in. Under the new law, it's now divided by 144 instead of 96. So the 104 increase now goes down to $69. Additionally, the phase-in takes longer. it's a 4-year phase-in, even with that decrease of an increase, because there's a 2% cap. So for the first year, it's $20, second year, $20, third year, $20, and the fourth year, you get to the $9 that's left over. You have a question?
Quick question. The rent guidelines board increases, how is that applied to them?
Yeah, so I simplified this because I tried to do an example that included the RGB increases. This is an increase, not a surcharge, right? Meaning that I did not do the math that shows that every year the tenant would still be facing rent guidelines board and you get the increase on top of the rent guidelines board because it becomes part of the rent and it has a compounding effect. So in fact, this is very simplified, but in real life, you'd be seeing rent guidelines board increases, which is why taking the MCI out after 30 years becomes really complicated because what are you doing with the MCI, with the rent guidelines board increases? IIs. So it used to be that if you went into an apartment, most individual apartment increases happened while an apartment was vacant. There was no application process. There was no oversight. And so a landlord could go into an apartment and basically do repairs and then take a 1/40th or 1/60th increase. What both the agency and actually HPD found was a lot of what went on in IIs was fraud, unnecessary. There was a sense on the part of HPD that landlords were delaying making repairs in apartments because it had a twofold result of both harassing a tenant out because their lives were so miserable, but it also saved them money. The apartment would get really run down, and then they would completely renovate the apartment, take the 1/40th, 1/60th increase if they were playing by the rules, and then hopefully, if they were lucky, deregulate the unit. There's been some really like Stellar Management, who's a big landlord in Manhattan, has been caught doing it with a kickback scheme. And a lot of landlords have just used this system, which was lawless and harmful, to harass tenants out. So the system has completely changed. And now, over a 15-year period, the total expenditures that a landlord will be compensated for are $15,000. The payback period is what is that? 15 and 16 years, 15 and 180, 15 and 14 years. It's 180 months and 168 months, whatever that adds up to in terms of math. So if a building has 35 or more units, the landlord can take 1/80th of this up to $15,000 expenditure and add it permanently to the rent for 30 years, and then it comes off. Again, I'm sort of unconvinced. But it doesn't say this. But what that means is that within the 15-year period, the most a landlord can increase the rent through IIs is either $83 or $89. And done. Owner use. Landlords can only get one unit. There's been a lot of tightening up of the language, but the days of landlords buying buildings and evicting all of their rent stabilized tenants so they can have a mansion are over. Those of you may remember the East 3rd Street Economacus case where that's exactly what happened. And I guess what I would say is that there is a lesson in so this was not on our agenda, owner use. I mean, it was like a secondary thing that we thought we'd go back to the next year. But as it happened, the assembly member who had watched those families be evicted out of their homes, ended up being the chair of the Housing Committee in the Senate. And so had been carrying this bill for a gazillion years because he had watched this, tragedy basically happen in his community. And so when the final deal was done, this bill was in there. So people pay attention to what happens in their communities. So it used to be that there was something called a 4-year rule, which was that if a landlord got away with an overcharge for 4 years, tenants, there was not much a tenant could do. So the law has been completely rewritten. There is a standard 6-year look-back period now. But there are a host of exceptions written into the law, including saying that the rent registrations are unreliable, which is defined in the law as an unexplained increase. And to the extent that the registrations are unreliable, you can go as far back as you need to. This particular provision, it was clear that it applies to all claims, including pending claims. And so we're seeing cases now that have been argued in the appellate division, in the courts, where the courts are all saying, yes, this applies, yes, this applies. So it's very exciting. We're seeing immediate results from this law, but I encourage, to the extent you're dealing with tenants should be looking at their rent histories, because now there may be an opportunity to challenge what has happened to increase the rents so much, some of which was not legal. There are a number of provisions in the statute, and this is just a little taste of them, that affect all tenants. So late fees, landlords can charge $50 or 5% of the rent, whichever is less. There's a very extensive security deposit law that goes into effect that includes a series of inspections from when you rent the apartment until you leave the apartment, to ensure that there's an agreement on the behalf of the tenant and the landlord about what the conditions were when you moved in and what the conditions are when you move out. Additionally, you can't have a security deposit for more than 1 month's rent. It's explicit in the law what a landlord could withhold the security deposit for. And there's a 14, after the tenant has moved out, landlords have 14 days to issue a notice that says, this is why I'm withholding the security deposit, or here's the security deposit. And to the extent they don't follow that provision of the law, they lose their defense in small claims court for getting the security deposit back. There's a strengthening of the retaliatory eviction provision, which says that if a tenant complains about conditions, about housing code violations, about building code violations, and now it's within a year, and then the landlord, for tenants who are unregulated, a landlord refuses to renew the lease. There's a way that a landlord can argue this is a retaliatory act, and what a tenant gets from winning that case is another year's lease. And so if you're an unregulated tenant who's being evicted because you make complaints, you might want to defend the case brought against you by raising retaliatory eviction. Tenants now have more notice of rent increases or landlord's intention not to renew the lease than they had previously. So if you've been in an apartment for less than a year, landlord has to give you 30 days notice of not renewing the lease or of over 5% rent increase. Up to a year, you get 60 days notice. Up to if you've been in the apartment for 2 years or more, you get 90 days notice of either the rent increase or the fact that the landlord isn't going to renew your lease. If the landlord fails to give such a notice, then the time for either of those actions to happen starts from the time they give the notice. You don't get to stay forever, but you may get an additional 90 days. Landlords, under the old law, if a tenant broke the lease, they could hold the apartment empty and simply charge the tenant the remaining rent on the lease. Now a landlord has to show that they've made an effort to re-rent the apartment. They can't just keep the apartment empty. There's discrimination that has been banned based on tenant screening reports. From my perspective, this is a fairly weak measure in the law because there's no, it relies on the Attorney General to enforce it. So there's no private right of action. And, you know, the Attorney General has a big job. So I don't know how that's gonna work. And application fees for new apartments, there's a bar limitation on those fees. Yes?
I'm sorry, I didn't mean to interrupt you. My understanding was shortly after the rent rules were changed, that agencies, brokerage agencies were charging a lot of fees and saying this didn't apply to them.
Yeah, so, so brokers are overseen by the Department of State, and the Department of State, New York State Department of State did put out a guidance saying that, that it did apply to them. And if you go on the department website, you can, they have like a way for tenants to complain if they're seeing it. It's just, it's hard, right? Because what happens in reality is you go and you try to get an apartment, they tell you you have to pay, I don't know, a couple $100. You say, I'm not paying the $100, they say, I'm not renting to you. And you can make the complaint, but the apartment's gone. But this is an attempt. Some of these provisions were put into the law because we had, the tenant movement had been fighting for good cause eviction. And there were a series of hearings across the state where people came and talked about how they didn't have any protections of lease renewals and they were moving every year, which is expensive. You know, you're not paying rent all the time, but you're also paying all these moving costs and all these application fees, et cetera. And so there was when good cause eviction was not part of the package, there was an attempt to try to protect unregulated tenants to make things better for them, and that's what this is about.
Question,
Yes.
to your point of the apartment's gone because you're not gonna rent it, is there a look back? So in other words, I pay the $200 or $300, then I make the complaint.
Yeah.
Can you require the broker or the landlord to actually?
I mean, I think you could bring a case in small claims court, and I think you'd win. Yeah. It depends on whether you have the money to outlay. Non-rent fees are excluded for non-payment cases. Rent demands now must be 14 days instead of 3 or 5 and must be in writing. Multiple court deadlines are longer. I'm not sure we're gonna see a lot of the effect of that in New York City because frankly, court deadlines were already longer in practice, even though courts in some parts of our state under the old law would allow someone to get a rent demand, end up in court, get a judgment, and be evicted all within 30 days. That's no longer the case, but that was never the case in New York because our court systems are just slow. Notices of evictions are now 14 calendar days, not 5 business days. And in certain cases, mostly around cases involving landlords deciding not to renew leases, it used to be tenants would have, if they continued to pay their rent, they would have up to 6 months to find a new place. Now, depending on the circumstances, they might have up to a year. And in breach of lease cases, think of getting rid of a washing machine or a dog. Tenants will have 30 days to fix the breach, not 10 days. So this is not part of the rent laws, but I was asked to talk about it, and I don't have much to say about it. But there's a new tenant, there's new tools for law enforcement for going after landlords for harassment on a criminal basis. So there's always been parts of the penal law that say that tenant harassment is illegal. No landlord goes to jail for tenant harassment. Even the notorious cases we've seen where landlords have gone to jail. They have not gone to jail for harassing their tenants. They have gone to jail for lying to banks or not paying their employees. So there's some new provisions that would allow the DA or the Attorney General to charge a landlord for harassment. It's all around whether they can prove that the landlord was trying to throw a tenant out, getting a tenant to move, and did certain bad acts. But these provisions are all, it's all about whether you have a district attorney who has an interest in going after landlords. We haven't found a lot of, it's been years since that we've asked district attorneys to charge landlords with harassment. I don't think we've seen it, but this was a provision that the Attorney General in particular lobbied for, and so we'll see what happens with it. And I think that's the end of my presentation. So questions? Questions? Yes.
So can you give us a thumbnail sketch of legal challenges to the law today?
Yeah. There are now 3. There are now 3 lawsuits brought against. So the first case that was brought on behalf of CHIP and RSA and a couple of individual landlords, and that case was conceived before the law was passed. The CHIP and RSA went to the firm and asked them to bring a case 18 months before the law was passed. And if you read the complaint, which I have because we've intervened into the proceeding on behalf of a number of tenant groups, it doesn't read like it's about the new law. It's actually about the old law. They spent a lot of time complaining about the city council renewing the rent stabilization law, which it does every 3 years, because they don't think it works. But their arguments are that it's a due process violation for the city council to to keep renewing the rent stabilization law because they don't think it works. They think it's a physical taking of their buildings to have to renew leases of tenants and to have to provide succession rights to their tenants' successors, which is part of the reason I'm saying it's about the old law. And they think it's a regulatory taking for this new law and the old law to tell them how to regulate their buildings. The second case adds a contract clause claim because they say the new law, preferential rent sections, changed their contracts and therefore it's illegal. And the third case...
I'm sorry, is that like an ex post facto contract? Is that what they're saying it is?
I guess, but I will tell you that multiple tenants had their contracts changed in the previous iterations of the law, and no one seems to be buying this argument because it's being argued in, it's been argued already in front of the appellate division because of some of the pending cases this issue has come up, and the appellate division hasn't entertained it. And then the third case is actually not against New York City, and it's a Westchester case. So here's the state of the law. No court has ever found that these sort of regulations are a physical taking. It's silly. The due process, if they are correct, that if you think that a law that has been passed was not the best way to do the law, and that is therefore a due process violation of you, all of the laws that New York City Council has been passed will be challenged. They're also arguing that property owners, that any law that affects property should have strict scrutiny because it's a fundamental right. And for that law They cite to, quite frankly, Windsor, which has to do with gay marriage. And so they're basically, they haven't been able to find a case in the, for a lot of their cases, they are citing to dissents, and they are citing to apparently Justice Story from 1823.
I'm sorry, but could you just pause for a second? They're saying that, what is a fundamental right? That owning property?
Yeah, and so
How do
they're,
they square that with eminent domain? Where, like, there was a Supreme Court case a couple of years ago where they took an entire set of buildings in Groton, Connecticut
I'm
because
sure,
there's a higher, better use.
I'm sure they would like to see those overturned. And then the third is that, that you can't do regulations on property or businesses. They want to overturn the entire, like 100 years worth of law. So where are we in terms of, I mean, the case is gonna be decided on motion to dismiss, because many of these same arguments were made in the Harmon case by the Second Circuit in 2011, and where the Second Circuit dismissed all these cases sort of summarily. The whole point of this case, beyond the fact that some of it is about making money, or some of it is about the real estate industry showing their members that maybe they lost this fight, but here's what they're doing. But some of this is about getting to the Supreme Court. So how is the Supreme Court considered rent control? So the last time the Supreme Court looked at rent control was in 2005, and it was about a commercial rent control law that was in Hawaii. And the case was called Lingle. And that case was decided 9-0, that it was not a regulatory taking. And on that 9-0 bench included Scalia and Thomas. So unlike a lot of the cases that we are worried about losing, that were 5-4 decisions that have been controversial over the years, and now we have a different court, that all the people who've been in the dissent for all these years are gonna end up in the minority in these 5-4 decisions, that's not the case when it comes to the court evaluating these sort of takings claims. And frankly, to the extent, there's no real difference between regulating a business that happens to be residential real estate or regulating a business in any way, shape, or form. And I know that we have bad times ahead of us with this court, that's my opinion, in a lot of different areas. But I do not think they're willing to overturn 100 years of law that would, take away the 8-hour work or 7-hour work period, or child labor. All of those things, all of those rules, there's no substantive difference between labor laws and and regulating residential real estate. And I don't think we're going to see it going back to the 1910s, the 1920s, when the Supreme Court was just overturning all of those laws. So that's where we are. We're in the process of motions to dismiss on in those cases, not the new case. We haven't intervened in the new case, but we will. The two of the cases are in front of Judge Brody in the in the Eastern District in Brooklyn. The Westchester case was brought in the Southern District, and it's in White Plains, and that happened last week. So.
I know you mentioned about the tenant screening bureaus and having a private right of action. It's currently a city council bill that will create a private right of action and allow the New York City Human Rights Commission to also take up action, so kind of lengthening the reach of the AG's office in a way. So it got heard last month, hoping for a swift passage.
I think we testified in favor of it.
Yeah.
Yeah, we did. I think that's the solution. I'm not sure that what was in this law is the solution to the problem. Yes?
It's just a legal question, I'm curious, and thank you everyone for your patience. What's the jurisdiction to bring an action in federal court?
They're doing it through what is it? They're doing it through the takings clause, which is a Fifth Amendment, and that's how they do it. Plus, it used to be that they had to go through state court before they could get to federal court, but in a case that had been decided in the 80s or 90s, 5-4, which said you had to go through state court before you got to federal court, that case was overturned last year. And they said, the court said that on cases involving takings and property, you could go straight to. That was a physical takings involving an actual property that was being taken from the landlord. But again, it was like one of these cases that was 5-4, and the conservatives were saying we need to overturn this particular case, and then they got it overturned. Yes.
So, are there any substantive, in legislation, any substantive changes or amendments being contemplated by the folks who passed this law? Are they hearing anything that seems to indicate that, well, we may have gone too far in this area, or maybe not far enough in others?
My understanding is the legislature has been told that every single thing they passed was too far.
Right.
From the mildest to the more sensitive. There's not one part of the law that the real estate industry hasn't complained about, and there's not one part of the law, and they've complained about it at the sort of the same level. So it's hard to, so co-ops and co-ops are unhappy that some of these provisions impact them. The landlords are saying that they're never gonna do repairs again. There's a lot of talk about how they're gonna stop doing lead abatement. I just wanna say one thing about repairs, is that none of the provisions that were passed have anything to do with the repairs. They were all about improvements. And so to the extent that the landlord were using the money they were getting, were saying they were doing improvements, but were actually doing repairs, they were already violating the law. There's nothing in the provision that would have allowed them to do lead abatement. All of the things, individual apartment improvements and major capital improvements, were about improving the building, not fixing the building. But landlords say that they're gonna stop fixing buildings. There's a Wall Street Journal article, as I mentioned today, saying that they've stopped doing any improvements in their buildings. They say they're not gonna rent apartments. In my opinion, that to the extent that they're correct, that things went too far, I'm not gonna say that, I don't agree with that. The idea that they figured that out on June 15th, which is, they've been saying the same thing since June 15th, makes it difficult to think that there's been any real analysis of this. Yes?
I don't know if the new law had any teeth for giving proprietary leases, tenants, those, any significant rights as compared to rent stabilized tenants. Would you recommend that kind of change in the law?
I don't proprietary leases as in cooperators?
Yes.
My knowledge, I represent tenants, so I don't have a real strong feeling about what rights cooperators need and changes need to be made.
Well, they have no rights virtually. So.
Yeah, it's not my area of expertise. I'm sure there are a lot of people who have a lot of thoughts about that, it's just I'm not one of them.
And would you recommend some changes in the housing court system? Because I don't think the new law covers that. Since as a practicing attorney, you've seen some glitches one way or another.
Yeah, so the law actually changed a lot in terms of the real property and procedure law, which are procedures in housing court. And I guess I'd like to see how those work before thinking about making more changes. But it's certainly, and then the other thing I would say about housing court, which is complicated, is I think a lot of the things that go wrong in housing court are the same things that go wrong in any court proceeding, which has to do with how judges interact with litigants, and that can't be changed by law. Like what you can do with housing court, because of separation of powers, the legislature only has so much power over how courts work. And so, I'm not sure I have any recommendations for changes to the Housing Court Act at this moment.
Would you be able to circulate that?
Yeah.
Yeah.
Yeah, we'll be sending it out.
Thank you very much.
Anything else? All right, thanks.
Thank you.
We are going to change the agenda and go to community board chair reports because a few people have to leave. And I'm gonna first call on CB9, who has some updates on Columbia University before he takes off. CB9.
Thank you, Ken Miles, reporting in for Barry Weinberg. Wanted to kind of touch first and foremost on the incident involving, the unfortunate incident involving Tessa Major, the Barnard student that many of you have likely heard about. She was, and so Barry kind of just provided a background, which I'll just read off. Tessa Major, an 18-year-old Barnard College first year, she had sought assistance at the Columbia Public Safety booth on 116th and Morningside Drive around 5 p.m. on Wednesday, December 12th, after being stabbed in the park after an attempted robbery. She was taken to St. Luke's Hospital where she passed of her injuries. The 26th precinct and the NYPD homicide unit believed that the perpetrators are 3 boys aged 13, 14, and 14. They are believed to have attended the same school together, although that's still being investigated. The 13-year-old suspect, who lives with his aunt and uncle, was taken before a judge in family court, where he testified that he was with the 2 boys when they attempted to rob Tessa Majors. When she resisted, one of the boys attacked her repeatedly. The 13-year-old remains in custody. One of the 14-year-olds was questioned by police and later released. CB9 issued a statement on December 13th following the attack and participated in a community vigil in Morningside Park that was held on Sunday, December 15th. The board is shocked by the tragic death of Tessa Majors, but is deeply concerned with the confession as well from the 13-year-old suspect obtained by police during a questioning at which the suspect did not have legal representation. The board believes that it is imperative that any suspects questioned by the police be questioned in the presence of counsel. The board is also concerned about reports that many juveniles with existing records were taken in and questioned by the police in the wake of the incident. The board is mindful of previous errors and improper questioning by police and the district attorney in other high-profile cases involving young boys in New York City, and it is determined that such problems not recur in this case. The board concurs with Borough President Gail Brewer's assessment that the city's drastic cuts in professional youth development funding and youth program funding, including after-school and weekend programs, contribute to conditions where youth are more likely to turn to crime. To that end, we will be working with local organizations and the city to assess the availability of such services to the youth in our neighborhood. We will also be attempting to secure additional mental health resources at schools and youth centers in CB9. Additionally, prior to the attack, CB9 had been advocating for additional lighting, cameras, and parks enforcement patrol resources in Morningside Park and St. Nicholas Park in response to an uptick in violent attacks and robberies. We remain committed to obtaining that funding for our parks. Finally, the board is dismayed and angered by the actions of the media and law enforcement regarding public information around this incident. Rushed articles have been published, which later turned out to be spurious allegations and half-truths. The board urges the NYPD and other officials involved in the case to not release information to the media until the veracity of such information has been confirmed. The board also does not believe that the names of the suspects who have not yet been convicted of a crime should be published by the media, given their young age. That's the formal statement as relayed by Barry. And
Thank you.
so I wanted to share that. Apart from the incident itself, the other nature of the report is reporting in on CB9 is still fighting a 400-foot tall development at 125th and Broadway by Columbia University. And they have actually signed on to Councilmember Levine's initiative for cross-Hudson ferry service between the West Harlem Piers and Edgewater, New Jersey. We're also looking to work with Department of Transportation to restore parking to areas along 12th Avenue where small businesses have been closing and laying off staff due to reductions in business. And that's the report as issued by
Thank
May
you
I have
very
a
much.
question? May I ask a question? Sure. Thanks. So when you're talking about restoring parking along that commercial corridor, is there any evidence that you can share, any outreach surveys, whatever it might be, that links the loss of parking to the vacant storefronts? Because well, certainly in my district, and I guess a lot of districts, we're all confronting vacant storefronts and looking for ways we can be helpful. And if parking, either the presence or the absence of parking is a good thing for businesses, it'd be great to have data
Yep.
rather than anecdotal,
Totally.
Yeah.
I'll be able to get additional information to you, but I do know that 12th Avenue has been a subject of kind of a more focused approach, so it's not just anecdotal. Like, there's definitely been an attempt to get feet on the ground, and in the last 2 months, we've started assessing how we speak to and engage with the neighbors, in part in response to projected timelines for Columbia's expansion, but also firsthand knowing that there are several businesses along that corridor that are, it's challenging as they kind of wait out what will be coming with what is, one of which, Floridita, we're watching carefully as well because they're in a precarious position.
Great. Let's talk offline, but that's having data around that would be really helpful.
I just want to add that last month, Barry Weinberg said that like a month after the street parking was changed, that the restaurants along 12th Avenue saw their revenues drop like by 30%.
Wow, okay.
So that was like immediate. And then since then, many of those businesses and restaurants have closed.
Can you share that data with everyone, because we have the same issue? Thank you.
Okay. So I'm going to move on with CB 12 to,
Because it's December, right?
because it's December, right? And in January, we'll start with CB 1, starting the
Good
reports,
for you.
and then move on there. Go ahead.
I'll be as brief as I can. We've completed the last phase of our speed changes for our internet. It's now 400 MIPS, which is the fastest amongst all the city, the community boards. It was quite a challenge dealing with Spectrum, but we got it done. And it works well with all of our equipment. I'd be glad to give you any advice, or at least our district manager will, in terms of how to implement that successfully within your own board. Tonight, we have a public information hearing on the renovation in February 2020 of the elevators at 191st Street and St. Louis Avenue. This is a very serious problem because of the George Washington Education Complex on Audubon Avenue, as well as Isabella Geriatric, which has employees, some 725 employees, and some 1,600 visitors a day. And plus there's some other ancillary schools and business that are going to be affected by this. They have to come up with a plan that does not divide our community from Broadway to St. Nicholas. It's a very steep hill to go there, so we can't use the tunnel to do that. The tunnel, just the elevators are closed. On Broadway, that is the pedestrian tunnel at near Fairview Avenue. And so something has to work out. So we are having this public information hearing at Isabella, and hopefully we will hear their plan, which I do not have any information on, and see if we could work it out. So it might involve shuttle buses and a few other things. It may not, but at least we've invited them early enough so that we could get some information and we can work out some solution. Finally, this will be my last meeting since I did not run for chair again. It's been a long journey. almost 9 years. 3 years as housing chair, a year as public safety chair, 2 years as first vice president, and a year as chair. So it's quite a lot of work I've done, and I'm pretty happy that I've had that opportunity and had the opportunity to have a collegial relationship with all of you. So thank you very much.
Thank you. Thank you, Richard.
Right.
And thank you for your service to your community and the board. CB 11, Nilsa.
Right, I have much voice. So, thank you. CB11 is going to be looking at the Lennox terrace rezoning because we're also on that line. And so we're concerned about the project itself. And we sort of in just informal discussion are aligned with CB10. So we will be looking at those documents, we're circulating those among our members so that we can also weigh in. Because we realize, and I would like to say that CB 9, 10, 11, and in some instances 12, have tried to form a coalition in certain issues that affect all of us, because we think that with unity there's more power in our voices, and so we're looking at that as well. Tonight, CB 11 is going to have a viewing at the East Harlem Health Center on gentrification and its effects on health. We are also this Saturday
I'm sorry, its effects on health.
its effects on health.
Terrific.
Yes.
Thank you.
And then this Saturday will be La Marqueta, which is almost like a quasi-landmark in East Harlem, has hosted 3 Harlem Nights. And so this this current Saturday will be our last one. It will be there from 4 to 10. And we've been in discussions, informal discussions with our council member and CB11 and other stakeholders regarding the old Pathmark site, Excel, as the MTA has taken part of that land. Excel is looking for different opportunities on how to develop, and so that's something to be determined. And with that, I'll just save the rest of my voice.
Okay, thank you. CB 10.
So, hi, I'm Charles Powell, the second vice chair. Want to echo what Nilsa just said about Lennox Terrace. I know there was a lengthy discussion at the last Borough Board, so we won't go into that. We want to thank the Borough President's Office for its decision on the application for the rezoning by the old organization, Lennox Terrace. And as Nilsa indicated, we are, continuing to meet and collaborate. We actually had an excellent meeting over the summer with 7, 8, 9, 10, and 11. I don't think 12 was able, to make it. Tonight, our land use is having a combined meeting with the Housing Committee, which I chair, and we are going to have the benefit of April Tyler from Community Board 9 will be there, and we welcome others to continue to come out. The Lennox Terrace scenario, I think the most important thing, I'm a lawyer, so forgive me for really focusing in on what I think the issue of plurality, and of course the preservation of our, history. Lennox Terrace is dead center, 60 years development, but remember, as we look at gentrification, we're now also seeing, the fact that, that's the Shelby versus Holder case, where, there was consideration of the connection of rezoning with the impact on voting rights. So, that's one of the things that we addressed in our, resolution. And it has gotten some, considerable resonance. We've spoken actually to Martin Luther King III, who, has supported us and is really saying that this might be something that has to play out throughout the country. So it's not the G word, that we're most concerned with. Gentrification is a reality. I mean, that's just progress and evolution. But we need to be sensitive, to the impact of plurality. There's a real concern in Central Harlem as to what things will continue to look at. So as we're preserving and moving forward, that's what we're looking at. And I just want to mention 2 other projects that's in our district, and Nelson, this impacts I think 11 as well, because I want to talk about the La Hermosa project, you know, which we opposed, which the borough president opposed. And that's on Central Park North, 110th and 5th Avenue on the west side. And that was an upzoning, so we're anticipating yet again, you know, a 40-story building or thereabouts, you know, on Central Park North. You know, no consideration of the impact, you know, on the park and shadows and things of that sort. But then we now know that Lincoln Correctional Facility has been closed by the state, and there's going to be an RFP coming out sometime probably in February. And what can we anticipate? And we know full well, Central Park North, yet again, views, you know, to the park, and so another tall building. So we really need to do what Nelson indicated, and I know Ken, we've talked about it, and all of us do, the Uptown boards, you know, really come together as we have, you know, to really talk about, you know, do we really need to really look at this rezoning scenario, or zoning in general, and with the help and assistance. By the way, Borough President's Office assisted us with Lennox Terrace, and thank you, because we were able to have board training on ULURP and board training on rezoning with the assistance of, you know, Borough President Brewer. And so we need somewhat of an overall strategy. I mean, our projects are, you know, we know East Harlem has had its, we know about West Harlem, you know, Central Harlem has not really, other than the 125th Street rezoning years ago, has not really had a comprehensive zoning plan that talks about preservation of Harlem as, Central Harlem as a historic, you know, district. I mean, so it may be too far to say that we want the entire, you know, all of Harlem to be, you know, designated an historic district. I'm kind of in agreement with that, but at the same time, you know, we're being chipped away. And so we just want to bring that to everyone's attention. And of course, not to take any too much longer, what 2020 census, you know, Census 2020 obviously impacts on all of that. So that is a major priority for our community board. And we've been working with, we have Judy Menon coming to our board meeting, you know, on the 8th of January. We have to be very intentional about working with all our partners, this office and all the city and, you know, and everyone, private and public, on making sure that we get our people out, you know, to participate in this digital census. So we've been working with, you know, with Silicon Harlem and others and Greater Harlem Chamber of Commerce, you know, to really get that word out intentionally. Opioid epidemic is just, I mean, really from a public safety point of view, it's killing us, as I'm sure it is in most of the other community boards all throughout the city. So maybe we need to come together, you know, collectively as community boards around something, you know, around this whole opioid scenario. You know, it's taxing, you know, everything. God forbid anyone has to go to an emergency room these days. And just from a noise perspective, I mean, does anybody ever think about how frequently we're hearing ambulances these days? I mean, it is every 2 or 3 minutes, something's flying up and down the street, and a lot of that has to do with overdosing and, you know, just people, you know, dealing with the opioid scenario. And lastly, we are focusing on trying to deal with technology and cybersecurity. So it affects not only our businesses, but a lot of our seniors and others, you know, who are being victimized by things that, thank God, Cy Vance and others have really been intentional about this, and we've worked with Greater Harlem Chamber of Commerce and Silicon Harlem again on, we just had a cybersecurity conference last week, so we should do more of that in the upcoming year of 2020, and thank you for allowing me that time.
Thank you. CB8.
Okay, Lenox Hill. So thank you very much to the Borough President's Office for convening a task force to try and stop this insane project where they want a rezoning and then variances on the rezoning to double and triple the zoned height. So I've talked about that. It is crazy. Liquor licenses, a minor thing, but there are a couple of instances where organizations seem to be bypassing the SLA and just doing what they feel like doing, which is not right. The landmarks letter that I mentioned the last time, I have a draft, I sent it to Rosie, so I welcome everyone's comments. On, someone I just met does the leasing for retail for a major developer, and he's talked about the low, again, the low purchasing numbers or ratios of people buying condos, and doesn't understand why they're still going up. And what he said was they go up because the banks are financing it, but he doesn't understand what people aren't buying, why they're still going up. And that affects all of these ongoing projects in areas that have been rezoned, as well as areas we're trying very hard to get zoning. We don't have a height limit. We can't engage with the city. There is just zero interest, which is why I want to talk to Barry. He mentioned that your board is working on that. So we asked for, at the City Charter Commission, a comprehensive city plan that would determine how things, infrastructure, and where these changes should be made. There should be mixed income resident, not just putting in these ridiculous market rate units and kicking everybody out and not preserving neighborhoods. And the administration has said, I know I've said this, that it just doesn't care, it only cares about growth. And the idea of a comprehensive city plan, I understand, was considered by the Charter Commission, but certain people on the board and on the commission and certain other interests prevented that. I don't know if it's something that is, well, all the city council people left, but if it's something that the city council could take up, is the idea of a comprehensive city plan. This spot, just putting up towers, just seems crazy. And then for people who are, and it should be everybody with the census, we've been doing a lot of workshops that have been really great on getting members of the community to sign up, to work, to go door to door if people don't do the digital, and trying to work with businesses to be centered, and the federal census people to be centers for people to come in and have help with a computer, or especially if they don't have a computer or something. So, and the person on our board who's been organizing these workshops, like, she's just a rocket ship with this stuff, is available. She said she would be of any help for anybody who wants. It's she's done so many of them, and they've gotten a lot of people in different demographics to sign up. We just keep pushing the census because it's so important. Okay, thank you.
Thank you. CB7.
Thanks, I'm Mark Diller. I think the first thing I want to talk about is the 96th Street ULURP. It's just a run-of-the-mill ULURP so it's not remarkable in itself, but there's two aspects of it that I thought are worth other boards' attention. One is the inclusion of this is a ULURP because they're selling, about a half the site is city-owned property, and it's a toxic site. So one of the community benefits is that they'll be cleaning up a long-standing former IRT substation toxic site that is on the hill, so all that lovely stuff is going down in the backyards of other neighbors. But what's interesting about that is that a lot of the affordable units that will come out of it are micro units. They're almost the size of college dorms. They're so small that the developer is making built-in furniture, including a Murphy bed and a pull-out desk and a microwave that comes from the ceiling. I made that one up. That's the only way you could make reasonable use of it. One of my board's concerns is, can you get a walker in there to turn around? Because if this is actually going to be marketed to seniors, and one of our recommendations is that they work very closely with our social service area folks in the community to make sure seniors are aware of it, whether this is in fact viable space. Flip side is, if you're a person who really has economic need, this might be a good thing. And that dovetails with our other major point about this ULURP, which is, and I'm sure you've all seen this too, that an awful lot of the units per the deal between HPD and the developer so far have been at 130% of AMI. And our board asked that at least 3/4 of the units be below 100% of AMI. There obviously is a need for what some people call middle-class affordable housing, but this is an unusual opportunity, and we think it ought to go a little lower than where they're at now. And that is just, like, as of last night, on its way to the Borough President's office, where we hope we'll have greater traction on that issue than we were able to get. I want to talk a little bit about 361 Central Park West, or 1 West 96th Street. It is the former First Church of Christ Scientist, an individual landmark and made entirely of granite. It's in a beautiful and imposing building. You may have heard a few years ago that somebody wanted to turn it into, what did the guy call it? Unaffordable housing.
Really?
Yeah, and thankfully that didn't happen. It would have turned the north wall into Swiss cheese, and anyway.
What an expression.
Now, the Children's Museum of Manhattan is the proposed new resident, but in order to adapt it for their use, a couple things need to happen. And the two that I want to mention to you are an enormous amount of rooftop addition that would basically take a terracotta roof and turn with a skylight and turn it into a party space or a performance space, and the neighbors are quite vociferous. You may have heard that Upper West Siders are not challenged when it comes to expressing their views. So we've been hearing a lot about that. And the other, which I think might be useful or a common thread, is that there are monumental stained glass windows, many, almost all of which have religious iconography, because this did begin life as a church. And there's a fairly interesting split as to whether or not one can force a secular institution to retain a 2.5-story picture of Jesus and Mary Magdalene in the Garden of Eden. My personal view is that stained glass is an interior element, not an exterior element. The exterior element is the framing and the mullions and the muntins and all that stuff. But what if a synagogue had bought it instead of the Children's Museum? Would we really make them keep a picture of Jesus? I mean, Anyway, you're going to hear a lot about that as the days and weeks to come. One of the things I'm happy about our board did was, in fact, it was clear that this was going to a disapproval. So we voted a committee, a protective disapproval, and invited them to come back and re-present with a new plan before they even get to landmarks. I hope that will work. If that process works, that might be of interest to y'all. We had a wonderful presentation on the Regional Plan Association report about NYCHA, although there is significant concern about the idea of using air rights, transferable development rights, as a way to pay for whatever NYCHA. I mean, obviously NYCHA needs every last dollar it can find, but giving away the store on that is something that at a minimum we're going to be continuing to look at. So they're going to come back in January to a land use meeting. This was a housing meeting. Anyway, and then two last quick points. One is the Department of Parks Marina people are going to be renovating the boat basin marina at 79th Street. Apparently you can't take your boat out of that marina except at high tide. So there'll be dredging involved, and dredging of course means that there's nasty, possibly toxic stuff that's been accumulating there for 50, 75, 100 years. So it'll be interesting to see what happens with that. That'll be happening at the same time that they're renovating the traffic circle at the Rotunda. So I might recommend that you use Columbus Avenue for a few years to get downtown. And the last is the mechanical voids. You've probably heard a lot about people using these crazy mechanical voids as a way to push their expensive apartments further into the air. There was a hearing at BSA yesterday about a project that happens to be in my district, but it could be in yours, where they have multiple mechanical floors, and honest to God, they were fighting over whether 18% of the coverage of a floor is sufficient to make it a mechanical floor so that the whole floor doesn't count for floor area. And that's the fight. The fight is that you don't count floor area for mechanical space because we all need them. And there's an actual zoning regulation that says that if it isn't mostly, the part that isn't being used for mechanical shouldn't be subject to the carve out. It'll be interesting to see what the BSA does with that. Those arguments are fully presented. They'll be briefed one more time in January, and then we should have a decision by the end of January, which ought to be an interesting one. Thanks very much.
Thank you. CB6 Molly had to leave. She again asked me about policies on street co-naming. I am trying to choose a date in January where there is not a community board meeting. What I'm doing is getting all of the policies from each board on street co-naming. I want to see if I can get it out beforehand, but at that meeting for the different boards, chairs and DMs to come and discuss their policies so that people can look at best practices, tweak their policies as need be for their board. And we never have the time in these meetings to roll up our sleeves and really, share information between board in that way. We did it last week a little bit with the land use at Lennox Terrace, but I think it'll probably be best if we do this in the evening so that the community board staff can come in addition to the chairs and the chair of the committees. So that's just a reminder. CB5.
Thank you, Rosie. Craig Slutskin sitting in for Vicky Barbara. We had a liquor license that we rejected this month at 1204 Broadway, which is at the 29th and 30th Streets. The applicant is Glass Ceiling Events, but essentially it's an organization called Luminary, which is a collaboration organization for women. We did reject it. The rooftop itself is about 3,700 square feet on the rooftop of a 4th-story building, enclosed by a glass structure having sliding doors, but it also has a retractable roof, so it does open up. Open 7 days a week with amplified sound for music and times of DJ. It is subject to the 500-foot rule, 74 people. But the issue is it's immediately adjacent to and abutting residential windows. The windows are literally like 3 feet from this rooftop. We actually had 2 sound engineering reports done, one by the applicant, one by the residents. They sort of obviously, not surprisingly, conflicted a little bit. Neither of them were all that comprehensive. They didn't address certain things like patron discussions, not just, as opposed to just music. We had a significant amount of turnout, mostly from the residents and the neighborhood association against this. We had probably 35 people speak or so. We did have some members of Luminary speak also in favor of the application. None of those people actually live in the neighborhood. They just actually use the space itself. And while we thought we don't have any question that this is a great organization, just given that the rooftop is adjacent to the residential building, and also questions about precedent of licensing this space, who knows who's going to be in the space after Luminary, we felt that it was not in the best public interest, and we rejected unanimously. The second thing I wanted to mention was we received a land use review application for a proposed zoning map amendment and text amendment for the Union Square South Hotel Special Permit Project. This area, this sliver of Union Square Park, encompasses CB2, 3, and 5. We're actually the smallest piece. We have a very small piece of it. And while we have certain objections to it, we do note that CB2 and 3 already expressed their opposition. So in our letter to City Planning, we didn't take a position. We simply supported the positions of 2 and 3. So I don't know if 2 and 3 want to talk about it in their reports. The last thing I wanted to mention was a modification of a special permit on a covered public space at 550 Madison, which is the AT&T building. The AT&T building has a covered public space of about 10,000 square feet with another 10,000 square feet of bonus floor area. And the applicant itself is providing a number of amenities. They're opening up the covered space by removing the enclosures on the street frontages and also replacing the cover with a new glass cover, so the daylight will be maximized. They're reconfiguring the covered space to provide a variety of opportunities and spaces for passive recreation. They'll have paths for good circulation between the adjoining streets. There'll be an increase from 238 to 279 seats. They're adding tables. They're going to be putting signs up to alert pedestrians that they can use the table. They don't actually have to buy anything. They can just sit there if they want to use it, which is a good thing. They're creating a 31-foot high window at the rear of the lobby, again providing increased visibility from Madison Avenue. They're developing the area in a much more sustainable manner. They're collecting rainwater and they're going to be using it for horticultural needs. They're creating additional public bathrooms. They're putting in a water feature along the side. The reason why we wanted to bring this up is that during the applicant was great during the POPs land use review. They're working with the community, they're engaging us, they took our recommendations, they listened to our concerns. They didn't have to. They are not, this is not part of any, they're not part of any city mandated mechanism. The development is not part of the East Midtown sub-district zoning. They just listened to us and they worked with us really well, and we wanted to bring that up. Because our fear that city planning is not necessarily taking into account the sentiments that our community has towards the continuing commercialization and optimal use of public spaces. This applicant was great, they worked with us, and we just wanted to commend them on that.
Did the board have any more information regarding the part of the parapet of the building that fell and killed that woman?
We don't have any information at this point, it still
Yeah,
is.
we've been looking into the permits, and so we'll call the office.
Yeah, I'll speak to Wally
And
as
just
well.
make sure we're both on the same page and have the same information. Okay, CB4, is anyone here? Okay, CB3.
Michael Marino, first vice chair, newly elected. I was the second vice chair.
Congrats,
So,
congrats.
Condolences.
Thank you. Yeah, no, really. So we had our elections last month. All of the officers ran uncontested. We did have some changes because our first vice chair didn't run, so I ran. We have a new assistant secretary and a new second vice chair, but we still have our same chair. But she's still not able to make these meetings because of her job at the DOE. So I'm here. You're stuck with me. Our full board meeting is tonight. It normally would be next Tuesday, but because it's Christmas Eve, we sort of had to rejigger our calendar this month. So our full board meeting is tonight. There's two things on that agenda tonight that have already passed through committee, but one of them is the final design of the East Coast Resiliency Project. So our Parks Committee has passed a resolution with conditions, a whole page of conditions, and that will be presented tonight. And actually DDC is coming to the meeting tonight to give the presentation they gave to the Parks Committee to the full board. So if anybody's interested, PS 188 at 6:30. And then the other thing that will be voted on tonight is a ULURP that we rejected. It was a ULURP that was trying to transfer air rights from a landmarked building on St. Mark's to a new construction for commercial space across the street on St. Mark's.
On that corner?
Holly Hamilton House, yeah.
Okay.
And basically, it was rejected. Every single person from the community that came to the land use meeting was against it. The building basically is not going to be any taller because it was rejected. It basically, they were looking to make the building wider and do the floor heights differently so that they can do a different design. Part of the reason it was rejected also was because we were basically a lot of the board members felt like we were being kind of blackmailed into approving it because they basically presented us with two buildings and said, if you approve it, this is what you get. If you don't approve it, you get this ugly building. It's the same height, but it's really ugly, and and it was just a really contentious meeting, and so that will be voted on by the full board tonight as well. We also had our training last month from an outside facilitator that came and did an amazing training for all our chairs and vice chairs and secretaries and the whole executive board about sort of how to lead and facilitate better meetings, and gave her a whole bunch of tools and tips on how to do that. And myself and our district manager haven't had time to do it in the month since, but a lot of stuff that came out of that are things that we're going to develop regarding sort of printed out sort of scripts that the chairs can use to how to open their meeting, as well as things that we can have at the tables at the meetings for the public about how meetings are run and what to expect and what not to expect. But if anybody's looking for a good facilitator, we use somebody, her name was Hannah, and she's from an organization called The Group Forward. Yeah, she was really amazing. This was the first time she had done something for a community board, so she worked really closely with myself and the district manager to develop the training, and it was exactly what we wanted. It was perfect. Other than that, I think I'm done.
Okay.
Other than I think instead of it being by month, it should be by when we arrived.
Oh, yeah, because you're here first all the
I'm here
time.
first all the time.
Can I just ask a question, Rosie?
Yes.
Was that training also about building consensus, or just about the
Not really. There was a
format of
little
a
bit
meeting?
there was a little conversation about consensus building and whatnot and what it meant. But it was really more about how to run the meeting and how to cut off people and not let them
The
feel
hook
like they're not
doesn't
being heard and whatnot. And so there was a lot of just tools and tips about that. And a lot of the chairs have already started implementing some of it, even though we haven't sort of given them the guidelines yet. You know, things as simple as having all the committee members introduce themselves before the meeting starts, so that the public knows who the committee are. You know, having things like this at meetings so that people know who people are and things like that. So.
Just the one that we did, I think I mentioned a few months ago that we did one, that was actually much more focused on consensus, because that was for the whole community board. So that's something that if you're interested in, we can connect you. I think we also videotaped it, and it might actually be on our website, but
Oh, great.
I'll confirm that.
Okay.
So
Thank you.
I think that information.
Yeah,
Well,
yeah. I think our district manager mentioned that she had mentioned it in her district manager's meeting also, and she's already been sharing information with some of the other community groups.
Okay.
Yeah.
CB2.
Carter Booth, and the chair of Community Board 2. I'll start off by saying we have spoken with him, the group forward, and are looking forward to having her come do some trainings and probably in February and March. And there was a lot of interest from our leadership in our board on having that type of training. We had some really good news. I wanted to thank Councilmember Chin's office and our Schools and Education Committee for their perseverance on the Bleecker Street School. The DOE has informed NYU that they want to exercise the option on constructing a school at LaGuardia and Bleecker Street. This is going to be a school focusing on a citywide inclusion model, and we're hoping that it's going to address some specialized programs for language-based learning disabilities. Our Schools and Education Committee has really been focusing on a lot of very specific issues, including dyslexia education, and we're hoping that it will meet some of those specific needs. Right now, a lot of the specialized programs that serve students with language learning-based disabilities are done outside of the DOE model, and there's a lot of, I guess, cases where there's reimbursement, so we're looking to have that focusing in on public school. The Soho NoHo Envisioning Report, which I keep mentioning every month, it's actually being presented by the plan sponsors to the public on January 8th at the Scholastic Building on Broadway. And then on January 15th, Community Board 2 is having a meeting to begin addressing that, which will be at the Laredo Theater at the Sheen Center. We've, over the last couple of months, we've had a few interactions with Google that is, has 3 new buildings that are going to be in our community board. And specifically, we met with them regarding 550 Washington, which is this old St. John's Terminal building. We're continuing to discuss with them some of the community benefit elements that they might want to choose to include in their as a right development, and we're looking forward to having them come and present in the next couple of months to the public. We had a presentation by the Urban Justice Center on new vendor legislation, Intro 1116 and 6817, which are sponsored by our local council members. Councilmember Chin and State Senator Jessica Ramos, and would lift the cap on street vendors. The street vendors had came and presented our full board meeting last month. We did not have a quorum at our meeting, but there was a lot of concern expressed by the 7 business improvement districts in our board, and this is I'm not sure with other boards if they had the same issues, but our bids concerns were that the existing legal vendors, they have a lot of challenges enforcing the regulations with them, and they had concerns that lifting the cap would create even more issues for them. We had some very good results with a land use matter, which was amending a restrictive declaration to allow some additional use groups, and the restrictive declaration was originally put in place to protect the meatpacking businesses in the meatpacking district, and we, in addition to some quality of life benefits, we were able to secure 3 separate community benefit spaces, one on-site, which was free. It's about a little less than 2,000 square feet for a community-based arts nonprofit, and an off-site space, which would be at roughly 50% of market rate for a service-oriented provider and arts-related nonprofit. So that's we thought was a very good outcome from that. I'll leave it at that.
Okay. CB1.
Hi, I'm Simon Swift. Good morning, everyone.
Morning.
A couple of items. Our biggest issue we're wrestling with now, communities coming to us, is on a site for 250 Water Street. Large parking lot that the Howard Hughes Corporation purchased about 6 months ago. Turns out it's also a brownfield site. About a dozen years ago, our board downsized that area so that any development there could not be larger than 120 feet. Howard Hughes wants to put a large tower there, and they're willing to make some deals around potentially a school, some open space, etc. And really also funding the South Street Museum, Seaport Museum. There's a lot of moving parts here, very contentious in many areas. It may come to a ULURP action, but it's a major issue within our community. The next couple of items also relate to us developing or being involved with a couple of working groups or task force. One of them is this whole issue of, it relates to liquor licenses, but it's large venue sites. And we have a couple of them in our neighborhood now, and another one applying. One is, the last one, is the Old American Stock Exchange. The building is landmarked, it's owned, but the owner wants to have a tenant come in that's Live Nation. And they want to have events up to 3,000 people with a liquor license. That's one issue. But now the old stock exchange is in the historic part of the financial district. If you wanted to put 1,000, 2,000, or 3,000 people, and I don't know how many Uber cars, in that neighborhood, which is now becoming residential, we're trying to figure out some rules about how do they work with us. We have several others already. 2 historic buildings are taken over by Cipriani, an English company called Spring Studios right down here in Tribeca. Pier 17 is a seaport. And, I mean, in one sense it's positive to see this development and economic development. However, the impact it has on a community that's becoming more residential is just probably unacceptable at some point. So that's one, we will develop a task force to look at that and invite you all to come up with ideas or participate with us. Along with that, congestion pricing we're all dealing with. And I constantly say to our members, I mean, congestion pricing as a policy is moving forward. The issue is, how do we deal with it? What regulations do we want implemented that protect our communities? We're working with the Borough President's office and Margaret Chen's office about the borough-based jail right here at the Civic Center. And then finally, the Mayor's Office of Resiliency, the EDC, and the Borough President's office. This week wants something called a Climate Coalition meeting. I'm not sure I'm ready, we have one meeting on it. I'm not sure I can give you the 25 words or less elevator pitch on it. But we have one section of our coastal resiliency, Fidei Seaport, that we don't, neither EDC or the mayor's office has a plan, other than suggesting we build outboard into the river. And so this coalition is to try and figure out what options really exist. And once we figure that out, how do we advocate for that? So this project will span beyond the de Blasio administration. And so we'll need lots of people involved and brought into whatever the plan is. That's my report.
Could I just add one thing, Rosie, or ask a general question?
Yes.
So on congestion pricing, could we all agree that there, and I keep hearing that there isn't, to have a Manhattan representative on the panel that's
Yeah.
making these rules? And if we have a joint letter from all the community boards, not that it will carry any weight, but the chances are better than if we do it individually. So,
It should be said, that's a great idea.
yeah, because it came up at our board last night in transportation, and that's one thing that we're gonna take up in January, starting looking at the rules, but for right now, before they get started in January, if we could do that.
You know, if I may, I think there, you could make a really good case to have two Manhattan
We
representatives.
should have, it should all
One
be
for the
Manhattan
boards that are in the
representatives.
congestion zone,
And
and one for the
not.
boards that are,
Exactly.
that are fearing what will come
Right.
as a border zone, you know?
Yep.
And that's why we should, so the ones
So
not.
you and I will flip
yeah.
a coin and,
And we should also work together on that, but I could volunteer to draft something
I
and
promise
send
there'll
it
be no
around.
signs that say free parking on the east side.
No, but we were gonna do that on the, we're gonna do it in Central Park on the transfers.
Well, if only Robert Moses were here, he'd solve it.
He would, he'd put a highway right
I think that's a great idea. Rosie, can I bring up one other thing I forgot in my report?
Yes.
I just want to thank the Borough President's Office for signing on to the letter with the other electeds regarding the DSNY issue with the garbage trucks that are constantly moving around our neighborhood. But I wanted to bring it up also because it's a perfect example of, I think, some of the challenges boards might face in the future with the new term limits, is because we were able to find an MOU because a board member who's been with us for decades knew about it from when Dinkins agreed
Wow.
and signed an MOU with Shelley Silver that garbage trucks could not live on the piers in our district unless they serviced our district. And we have garbage trucks from District 6 in our district, and I think District 2 in our district. So that MOU was sent with a letter from Gail and Margaret Chin and our state senator and our state assembly person, Judy's mayor.
Any other things that people forgot to add to their reports? So, okay, we're gonna move now to the Borough President report. I'm gonna ask Jessica to join me. The most important thing is CB applications are live and applications are trickling in. So, really, need the assistance of the CB staff and members to, you know, first, reapplicants. We were trying to do a competition, the first CB that got all their reapplications in, that has gone so slowly, we're doing the first 50 people. So the first 50 people we reached, I think it was December 12th. And we had 50 reapplications on December 12th, I don't remember, we've gotten more applications in, but I just don't remember those numbers. And at that point, we only had 16 new applications. Mostly all the boards have 1 or 2 vacancies, except CB 12 doesn't have any. And CB 11, we just had a couple of vacancies recently, so now you got 4 vacancies. My concern is that we get a vibrant applicant pool so that we can fill those vacancies and particularly try to address your needs. I've met with some chairs and DMs. I've not been able to get back to everyone and meet with everyone, and I apologize. I've had some emergency issues that have necessitated me leaving the office, so I haven't been able to make all those meetings, but I'm gonna try to get to them now coming up. Whoever's around in the next week or so, I am here and trying to make sure we get those meetings done. Yes?
So we have been making a push for the reapplicants, and you've actually been notified by some people that they're not planning on reapplying. Do you want to know that information?
Yes, and actually, when I've met with some of the DMs and chairs, they've been giving me that information. So that's been helpful, and some of it is a vacancy that may happen in 2021, but still that will be helpful to us. Particularly for those of you who have youths on the board, figure out when they're leaving to college, if they're planning to leave New York City. That's an issue that's come up where that's not been flagged ahead of time, and then we have a midterm vacancy or a vacancy shortly after they've been reappointed. So just asking you to take a look at that.
We have reposted the link on our website, so also as giving another boost that
Yes.
we can help as well.
We are going to be doing advertisements on social media. I went through each board to look at the population of the board and the demographics of the community as opposed to the board. And so in those CBs, we'll be looking to get more
Balance.
Asians, Latinos, African Americans, women. There are some CBs that do not have any LGBT person, trying to get at least one on some of those boards. And again, some of this stuff is how people identify. So if they don't disclose it, it still comes out as a 0. But trying to make our boards very diverse and just letting you know, as opposed to some of the other boroughs, you know, our vacancy rate is very low. This, from April until now, until October, we stopped filling vacancies in October. We filled 16 vacancies, and we were not able to fill about 10 of them. And now since then, we have 20 vacancies throughout the 12 boards. So that's where we're at. I've asked DMs, I'm gonna send them another letter to add a tagline on their signature, on their email's address that has the link and the deadline for the applications so that people can see it and just click on it and then get right to the website and to the application. I think that's very helpful. Any assistance, we would appreciate it. I'm gonna be doing outreach to certain organizations. Again, from the conversations I'm having, some people would like some preservationists, some people would like residents of NYCHA because of all of the infill that's been happening. And so we are going to buildings and dealing with some of the not-for-profits, preservation organization, architects, whatever, and asking them to do outreach. The architects last year did a really good job, the AIA, of reaching out to folks and getting a lot of applicants. And so trying to give the boards and us a lot of choices in terms of filling those vacancies. This week, there was the Manhattan Count Committee was reconvened here. A lot of the information is stuff that was presented at last month's Borough Board. But, you know, the big thing is recruiting. They are still recruiting. They're going to be doing recruiting through February. They need to hire in Manhattan alone somewhere between 10 to 15,000 people, census takers. And throughout the state, 180,000 people. And in New York City, 80,000. So some of the boards have been working with the Census Bureau and with our office in doing job fairs and recruitments, and any of those opportunities that come up will be helpful so that we can help them recruit and get people. Yes, Alita.
We had Jolie from the census come to the Veterans Committee, and they give preference to veterans if it's an issue for anybody. I mean, if that helps.
Thank you.
Just also on the census, so there's, you know, we had done some grant making from this office. We funded a few groups that presented and are doing some great work. The city funded a lot more groups, and, you know, we have all those lists if you're interested. But then the next thing that's gonna happen is that the governor has made a bunch of state money available, and that money is available for county executives. And in New York City, there really aren't county executives, but there are borough presidents. So we get the money.
Yeah.
So we're probably gonna have about $400,000, which we're gonna be able to, for the most part, distribute again to community groups that are doing really good work and reaching hard to reach communities. So, you know, we'll have a lot more information, but we're hoping that is gonna be available in January at some point, the census.
Jessica, is that for hiring, or is that for the actual rollout of getting people to fill in the form?
It's getting people to fill out the form, so it's the same types of things that we funded for. It's groups that are reaching hard to reach communities.
Great.
Or traditionally undercounted communities.
Okay. Earlier this month, there was a reception for the Borough historian Rob Snyder. Many of you were there, and so he is now on board and physically here and meeting with different people in the community. In the background table, when you walk in, there is flyers for our holiday diaper drive, and there are flyers for CB recruitment, and we can actually email you the flyer if you want it, and you can print them out. We encourage everyone, when it comes to the CB's application, to go online, but we do have a paper application, and for those of you who need it, we can get you as many copies as you need, and we could also send you the PDF version, which Richard asked for the actual PDF version so that they can copy it. So that is available, and you can just make the request with the number, and we will get it to you. NYCHA, is there an update on homes and the Fulton Houses Working Group?
Well, they're two different things.
Yes.
So, yeah, no, you want to.
Yeah,
They're
so
both
homes,
NYCHA.
our lawsuit against the proposed development in Holmes Towers was dismissed as moot, basically because we won. The city withdrew their plans for that particular development. We don't have a good idea exactly what they're gonna do. We've been told they're not gonna do a new RFP, so that may limit the changes. But we just have to wait and see and be ready to scrutinize what they put out. Our position, though, Gail's position, is that whatever they put out requires you going through ULURP. So we 99% sure that we will do a new challenge to whatever they put out, since they don't sound like they're ready to put anything through ULURP, since it would have an effect on all their infill that they're planning, throughout the city. So they really can't compromise on homes for this one thing, since it would set a precedent. And we hopefully will again be given permission by Corporation Council to hire outside counsel, since we work together terrifically. And we're on it. We're waiting to see what they come up with next.
Sure, so, our office, along with other elected officials, has been, meeting with a group of stakeholders, to sort of look at different options for funding repairs at the Fulton and Elliott Chelsea campuses. Tonight, there will be a mayoral town hall, where folks can come and sort of, give their concerns, to the mayor. And, we expect that the process will yield a series of recommendations that can then form the foundation for, what an exact solution will look like for those two campuses. And the recommendations are expected to be out at some point in late January.
Okay. The Religious Facility Task Force that the Borough President has created is gonna have their second public hearing on January 10th. And regarding Lennox Terrace, which we've been talking about a lot, the Borough President finally submitted her ULURP response, and it is a no, big N, big O. Just don't want it, don't need it. Okay, did I miss anything?
Nah, that's okay, that's it.
Yep, okay, yes.
The Religious Facility Task Force, that has to do with houses of worship that are falling into disrepair and having trouble meeting their maintenance budgets and things like that?
Or just selling their sites to
Selling their
developers,
sites to
whether they're in
developers.
disrepair or not. And
Sounds like a great initiative. January 10th during the day or in the evening?
So just to recap, so the Religious Facilities Task Force is actually really interesting. It's for all houses of worship, because at some point, everyone has financial difficulties. So it's a question of, you look at historic preservation, do you look at selling to the highest bidder, do you look at trying to do community benefit into affordable housing, and if so, what are the, things that are available to you? So we've had HPD present. We've had some developers present who are, working on some really good projects. It's been a great task force, and we're gonna end up with some kind of product that's actually gonna be available for religious institutions to look at all the different options available to them, and what are the resources out there. So as part of this process, we're doing public hearings. We did the first one last month, I think it was, or earlier this month, I can't remember. Alita, I know you were there. And it's just a really good discussion, because in the public hearings, everyone can come and sort of talk about either themselves, their neighborhood, or group they're involved in, a concern they have about the church on the block, whatever it is. Those meetings are also live streamed, so if you can't make it, you can watch live stream. So the next public hearing is January 10th. It'll be in the evening, early evening, and again, it will be live streamed.
Great.
And it will be here.
And here,
One of the things that, not to go back over the community reports, but when I reported about First Church of Christ Scientist, one of the things that was interesting is that there was a congregation that apparently occupied that space, I think as a tenant, or a subtenant of, who came and said, give it back to us, and of course it wasn't one of the options on the table, but they were very well represented, and it was a very compelling presentation. So anyway, perhaps I'll make sure they know about this.
Really tell them this, I think that the next thing we're talking about, we've talked, again, about historic preservation, affordable housing. We're gonna be talking about, some churches actually are able to sort of almost condoize spaces within the institution, which is then eligible for public funding, because they don't serve a religious purpose. So there's a whole lot of, options out there. So.
Sure, thank you.
At this month's meeting, they discussed alternate build-outs, and one of the things they were looking at was at community land trusts. So that was something that was discussed at this religious task force.
CB3 knows about that from your program. That was a big thing.
Sorry, yes, you presented that.
I don't know about it personally, so I can't.
No, but I
talk about
was
it.
at that thing, and so that's why. So Nilsa, if you're talking about community land trust, there were people at this panel at CB3 that were advocating or had been involved in the community land trust down there. Maybe, I don't remember if it's around Cooper Union or not.
Cooper Square.
Square, yeah.
That's probably Valerio or Sally. Thanks.
Sorry. It was a great panel.
All right, is there any representative still here from city council members? No?
Everybody ditched.
Okay, well, yes.
The public advocate's office.
Would you like to give a report?
Yeah, so the briefest report I'm have prepared remarks is that the Public Advocate's Office has created the Borough Advocacy Unit. It's the first of its kind. There have been representatives of boroughs, but this somewhat modeled off the Mayor's Community Affairs Unit is a group that's kind of triaging between community affairs, intergovernmental political relationships, and some of the policy areas. And we have the unit, we're going to be the biggest team in the Public Advocate's Office. It's a new structure. It's a new way we're looking at the Public Advocate's power. That's why people were excited for Jamani Williams to be it. And he's using community organizing, relationships to community, and his kind of bully pulpit, that name recognition and relationship with the media, like looking to see what he's saying on issues to support communities. I have begun, I'm the Manhattan Borough Advocate, that's why I'm here. I've begun to go to community board meetings and meet some of you, as I've met Mark, et cetera, and excited to do something with the other community board. So I just wanted to say that the Public Advocate's Office is excited to be here, and thank you for the invitation. And you'll be seeing myself, and once we continue to hire our community liaisons, like we'll figure out how we can be engaged and support the issues or what the electeds in your community, and just kind of advocate your voice on issues and see where we can move the needle and so forth through the Money Williams office. And my name is Philip Ellison, by the way.
Thank you. Thank you very much. So, do I,
OMB's here also.
OMB, you want to make a report?
The charter mandated date for the release of the preliminary budget is January 16th. If that remains the date, and that's the date that the budget is released, usually 1 hour after the mayor completes his press conference, OMB posts all preliminary budget documents on its website, including our register of community board budget requests and the agency responses. So if we stick with the 16th, you'll see them. May usually has a press conference at the end of the day or in the afternoon, so you would see them late in the afternoon on the 16th. The very next day, we email you your board-specific register. So again, that depends on if we stick with the date of the 16th. The other thing is, according to the charter, that starts the clock for preparing your letter of comment. The letter of comment is due 30 days after the release of the preliminary budget. So again, depends on whether we end up releasing on the 16th. And certainly you can contact me if you want a copy of your letter of comment from last year. So you can use that, to help guide you in putting together your letter of comment for this year. Thank you.
Okay. And is anyone else, before I ask for a motion to adjourn this meeting? No one else. Is there a motion?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Thank you.
Thank
See you
you.
next month.
Happy
See you
hol-
in the
happy
new
holiday,
year.
happy holidays.
Hi, Julie.
I'm okay, you're sick, huh?
Yeah, I'm gonna go see the doctor. I saw